Okay, good afternoon. Today we have Zachary Clopton, and he's going to talk about climate change in court. And Zachary's an associate professor at the Cornell Law School. He came to Cornell Law School via Yale University, where he got his BA, a Master of Philosophy and International Relations from Cambridge University, and his law degree from Harvard. His research and teaching interests include civil procedure, complex litigation, international business transactions and litigation, and national security law. He's clerk for the Honorable Diane Wood of the United States of Appeals for 7th Circuit. He served as Assistant United States Attorney in Chicago and worked in the National Security Group at Winter Hill in Washington, D.C. He also served as a public fellow at the University of Chicago Law School before joining Cornell Law School. So let's welcome Zachary Clopton and hear about climate change in court.
Thank you so much for being here. Thanks to Dr. Hess for inviting me. I'm going to talk to you today about the role of law, and more precisely, the role of lawsuits in climate change policy. A brief outline of where I hope to go this hour. I'm going to start by explaining why the standard model of environmental litigation is an uneasy fit with climate change. And in so doing, I'll give you a little bit of background about the US legal system that will help you put these lawsuits in context. Then I'm going to turn to 4 categories of lawsuits that I think can contribute to climate action. Then I'll say a few words about some of the common criticisms of these lawsuits, and I'll tell you why I think those criticisms are wrong. In short, climate litigation, climate lawsuits are not going to solve climate change, but I think that they can be an important part of a broader social, political, and legal movement around climate action. I thought I'd start by saying a little bit about how I got here, and Dr. Hess gave you a little bit of that background. I practiced first at a law firm working on national security law. I went to clerk for a judge on a court of appeals, and then I was an assistant United States attorney, meaning that I was a lawyer for the United States Justice Department, working on a range of civil law topics. I then became a law professor, first at the University of Chicago, and then here at Cornell. And I study the way that law and lawsuits can be used as a tool to solve problems of public policy. I'm not an environmental lawyer. I don't teach environmental law. I've never prosecuted an environmental crime. Instead, I have expertise in the way that we structure legal systems and we structure lawsuits in order to further various goals of public policy. But climate change is among those. Indeed, my view, and perhaps I can convince you of this view over this hour, my view is that climate lawsuits are among the most interesting and creative types of complex lawsuits that we have going today. So I'm not going to talk to you about the science of climate. You'll have plenty of other places that you can get that. I'm going to assume that climate change is real, it's man-made, and it demands action as soon as possible. Instead, I'm going to talk about how the law and lawsuits in particular can help provide some of that action. I also teach down at the law school where the typical mode of teaching is what we call the Socratic method. I point at one of you, call you Mr. or Ms. something, and ask you questions about the reading assignment. I won't do that today. It seemed a little unfair. But I will hopefully leave time for questions at the end. And I told Dr. Hess I could stick around afterwards as well if people want to continue the conversation. So with that, there we go. Let's talk a little bit about the US legal system. A little bit of background that will help you understand what's going on in climate litigation. So the first important distinction in the US and many other legal systems is a distinction between civil and criminal law. This distinction, it turns out, is actually not so simple. But for our purposes, you can think about criminal law as law that is enforced by the government, enforced by prosecutors who bring criminal cases where the ultimate penalty is that a person is sent to jail, is ordered to pay a fine, or perhaps under some circumstances, sentenced to death. Civil law and civil litigation, on the other hand, are the kinds of lawsuits that you typically hear about between two people. You get in a car accident and you sue the other driver. Typically, these are cases brought by a person who's harmed against the person who harmed them. And typically, these suits are brought for money, although they can be brought for other types of remedies that I'll say more about in a little bit. There are a lot of reasons why this distinction makes a difference. The standard of proof is different. When you get a jury is different. All sorts of differences we don't need to worry about. And indeed, there are many situations where civil and criminal law overlap. The crime of murder overlaps with a civil claim for wrongful death. So I've spent lots and lots of my time thinking about this distinction. For our purposes, we don't need to worry about it. We're going to ignore criminal law for the moment. And we're going to talk only about civil litigation, which for the most part is what's going to matter for climate change. Within civil litigation, we should further kind of separate out the world into two categories of civil lawsuits, what I'm calling here public and private. In the United States, many areas of law rely substantially on litigation, on lawsuits, as the enforcement mechanism. Antitrust law, securities law, civil rights, employment discrimination, environmental law. It's one thing to say that something is not supposed to happen, to say that polluting X amount of a pollutant is prohibited. But the important question, at least for lawyers, is how do you enforce that requirement? You don't just snap your fingers and all the pollution goes away. And the American system, almost more than any other system in the world, relies on lawsuits in court as the way to enforce some of our most important public policies. Now, who brings those lawsuits? Here too, the United States system is somewhat unique. I guess you can't say somewhat unique. It's somewhat unusual in that the United States relies heavily on a mixed system of both public and private lawsuits. Public lawsuits are lawsuits where the person bringing the suit is a government actor. It could be the federal government or the EPA. It could be a state government. It could be a city government. But sometimes we rely on private lawsuits by individual citizens. You or I can bring a lawsuit to enforce the antitrust laws of the United States, the laws that prevent businesses from engaging in monopolistic behavior. The US system has lots and lots of areas in which we rely on overlapping public, that's government, and private, that's you and me, civil enforcement. In other work, I've referred to this as redundant enforcement, but not to criticize it, but just to identify the fact that these are overlapping systems of enforcement. I'll say more about that a little bit later. Last background point that's important to know about the US legal system is that in our system, there are various ways that individuals can sue the government for redress. For our purposes, the most important category of these lawsuits are lawsuits against the government, where the government has failed to do something that it is required to do. That could be something small, like some procedural technicality, or it could be something big, like fighting climate change. This, by the way, is contrary to the kind of old model in which we had a doctrine known as sovereign immunity, which was that the king or the queen, or today the government, is immune from lawsuits. Used to not be able to sue the king because, of course, all law came from the king, so it made no sense to say that the king was violating the law. But over time, those limits have fallen away, and so today there are multiple ways, I'll again say more about this later, that individuals or other government actors can sue the United States. So, with that background in mind, let's talk a little bit about environmental law. And I want to start with what I'm going to refer to as the simple model of environmental litigation. Imagine two neighbors. One routinely hangs the family's clothes on the clothesline to dry after washing them. The neighbor, who's got the little house in the picture, decides to install a new wood-burning stove. The new wood-burning stove releases a little bit of black smoke that you could see coming out of that chimney. That smoke, as smoke does, doesn't stay within that person's property, but flows across the property line and stains the clothes hanging on the line. Well, what should that first neighbor do? Well, one thing they can do is sue. The kind of lawsuit that we call nuisance, or in this case, private nuisance. So the first neighbor goes into court and sues for nuisance. Now, the court could do all sorts of different things. The court could say that the neighbor who installed the wood-burning stove has to pay up. They have to pay the cost of cleaning the clothes or replacing them. Or the court could say that the neighbor is banned from using the wood-burning stove going forward. The court would issue something that we call an injunction. It's an order to not do something. Or the court could say, sorry, people install wood-burning stoves all the time. And that's what you get for living in a city. You have neighbors, there's pollution, and sometimes your clothes get stained a little bit. In that case, they would say that the lawsuit fails. They would rule in favor of the neighbor with the wood-burning stove. This actually turns out to be a long-running problem in environmental law, who should win. But we're not here to talk about who should win. What's relevant here is that the way that the court behaves, the way that the lawsuit works, is pretty straightforward. Person who claims to be harmed sues person who they think harmed them, and the court decides who wins. A sues B, just like after a car accident, just like after a breach of contract, just like the infringement of a patent. It's a very simple two-person dispute where the court just decides who wins and who loses. And once they decide who wins, they decide what the ultimate resolution is going to be. That's the simple model. Now let's talk about the tragedy of the commons. Are you all familiar with the tragedy of the commons? A lot of nodding here. So the basic idea of the tragedy of the commons is that we have a village with a common grazing space. And in this horrifying YouTube video, it's horrifying not just because the tragedy of the commons is horrifying, but these farmers and cows are giving me nightmares. But it was a nice one that fit on the slide. So in this particular tragedy of the commons, each farmer can have 4 cows that fit on the land. They can graze, no problem. Now imagine the red farmer thinks, you know, wouldn't it be great if I could double my herd? I could have 8 cows. That would help my family. I would double my wealth, and everything would be fine. The commons is big enough, it can accommodate 4 more cows. So the red farmer adds 4 more cows, and it works. What makes this a tragedy is that if each farmer does it, the entire herd doubles, there are too many cows, and the commons will be destroyed. Everyone will lose out, all the cows will starve, the entire village economy will go in the tank. So the key insight of the tragedy of the commons is that the pursuit of each person's individual economic interest, when everybody does it, adds up to total social devastation. Climate change, of course, is a tragedy in the commons. If we all emitted only what we absolutely needed, the planet could survive. If I decided that I wanted to emit a little bit more in order to improve my family's wealth, we still would be okay. The problem is when everybody overpollutes, it results in planetary devastation. Now, I raise this example of the tragedy of the commons in this context because tragedies of the commons are actually pretty poor fits for the simple model of litigation that I described before. When you have a tragedy of the commons, it's not obvious who should sue, whom they should sue, what they should sue about, and what they should ask the court to do. It's just not as simple as A versus B. Or, to be more precise, and to teach you a little legal jargon along the way, tragedies of the commons are difficult because they pose a series of legal questions where the answers are not going to be so obvious. So here I'm going to give you my second little bit of background about how the US and many other legal systems work. I know many of you read this report about climate litigation that was circulated. I'm going to mostly use the same terminology, although there may be some slight differences in how I label these concepts. So here I want to talk about 3 categories of questions that lawsuits have to answer in order to be successful. So the first is that you need to have what the law calls a cause of action, or a right of action, or a claim. You have to sue for something. Breach of contract is a claim. Assault and battery is a claim. Patent infringement is a claim. So if you're trying to think about a tragedy of the commons, you have to articulate, well, what's the claim that I can bring against another person? When you're thinking about the claim, you also have to figure out, well, what's the source of the law? It turns out there are a lot of different sources. There's federal law, state law, local law. We have international law. There's foreign law. So one question is, what's the source? But the other issue is what the law calls the merits. You don't just get to walk into court and say, he breached my contract, and win. You have to prove it. You have to win on the merits. You have to show you deserve to win. And once I tell you that you have to show that you deserve to win, it becomes obvious that litigants have what I call here a problem of proof. You have to prove that the other person did in fact harm you, they did something wrong, and that you deserve to be paid. So all litigants have to identify a claim under a relevant source of law, and then they have to have enough proof to show they can win on the merits. Second category of issues are what I'm labeling here justiciability and jurisdiction. So justiciability is about whether we have the right parties, whether it's the right court, and for our purposes, the big category here is something the law calls standing. Standing is who gets to sue. If I witness a car accident on Campus Road, I can't walk into court and sue one of the drivers because I wasn't affected. Typically, the law says only a person who is harmed by the person that they're suing has standing to sue. The other issue here is what's called jurisdiction. Are we in the right court? Lots of technical legal questions, which you don't need to worry about which is the right court to sue in. And even if you can establish that the court has jurisdiction, the law has a set of doctrines that are called abstention, which are basically the ability for a judge to say, even though technically I have jurisdiction here, this is not the sort of case where we want a court to get involved. I'm going to abstain. I'm going to use the doctrine of abstention to get out. So you need to have the claim, you need to have standing, and you need to have a court that has jurisdiction. Finally, you do all of that, you prove on the merits that you're going to win. The court has to figure out the remedy. What is it that you get at the end of the lawsuit if you win? You can get what we call damages. That's money. We can get an injunction. That's an order to do something or to not do something. Or you can get something we call declaratory relief. The court simply announces the rights and duties of the parties. So all of these bullets, it turns out, are difficult questions for climate lawsuits and for tragedies of the commons in general. When you face these situations, it's not entirely obvious what the claim is. It's not obvious that it can be proven. It's not clear who has standing, which court has jurisdiction, and whether the court's going to take it. And finally, if a suit is successful, it's not obvious what sort of remedy the court should issue that will resolve the underlying claim. So I told you that for those reasons, tragedies of the commons are not obvious cases for climate lawsuits. There are not so many obvious A sues B cases. But that doesn't mean it's impossible. And thanks to some creative lawyers over the last decade or so, there have been a number of climate lawsuits that have some hint at success. I'm going to describe for you now what I think are 4 categories of climate lawsuits that I think can make a difference. The first category are the closest to those A versus B lawsuits. These are direct lawsuits, typically against fossil fuel companies or other emitters, that are trying to prove direct harm from climate change. And it turns out, for a bunch of reasons that I don't need to get into here, a lot of these lawsuits have been filed not by individual citizens, but by states and cities. Unsurprisingly, liberal states and cities like New York, like San Mateo, like Connecticut, which I'll describe in a minute. So these are government agencies filing civil lawsuits, or what I told you before is called public civil enforcement. So an early example of this lawsuit failed. This is a case that went to the US Supreme Court in 2011 called Connecticut versus American Electric Power. In this case, Connecticut and a handful of other states filed a lawsuit against the 5 largest emitters of fossil fuels, claiming that they were polluting the atmosphere with carbon. Case goes all the way up to the US Supreme Court, and the Supreme Court basically rejects all of the claims in the case. They say that these states did not have a claim, a cause of action. They didn't have something to sue on against the polluters. Though the court kind of implied that there were some small slivers of liability that might be left over for later cases, but they weren't really relevant here. Well, since that time, creative lawyers have picked up on those slivers of potential liability and filed lawsuits against emitters. One such case is called New York City versus BP. So on October 29th, 2012, Hurricane or Superstorm Sandy hit the East Coast of the United States. New York City was hit particularly strongly. There was flooding across the city, including throughout the subway and the Ground Zero construction site. More than 50 people died across New York State, and more than 100,000 homes were damaged. So based on these events, the city of New York filed a lawsuit against major fossil fuel companies. And they asked the court to award them $20 billion in damages. They argued that they needed $20 billion to pay for the losses that came from the hurricane, and they needed that money to build up the city's defenses so that it could be resilient against future weather events linked to climate change. So first and foremost, this is a lawsuit about money. New York City would like $20 billion, who wouldn't? And indeed, I think New York City would be very happy getting a lot less than $20 billion if they were able to do so. But of course, this lawsuit is also about more than just a one-time payment. It's also a political statement. It's a political statement that climate change is real, that it has real consequences for people's lives. It has real consequences for things like Hurricane Sandy. And the city of New York and its allies are trying to link up the abstract idea of climate change to real world damage, and they attach a $20 billion number to that because it gets people's attention. Another example that I have up here is San Mateo versus Chevron. Here we have the city of San Mateo, which is in the Bay Area in California, suing Chevron and others, also for climate-related harms, here connected with rising sea levels and flooding. I've spoken with some of the lawyers for the city of San Mateo, and they tell a similar story. They're lawyers, so of course they're suing for money. They like their attorney fee at the end of the day. But they also understand that this is a political issue, and they think they're making a political statement when they're suing fossil fuel companies related to climate change. More generally, this entire category of lawsuits I'm describing, lawsuits directly against fossil fuel companies and other emitters, I think is trying to do at least two things at once. First, they're suits about money. They want to help cities like New York rebuild after Hurricane Sandy and to become more resilient going forward. But second, they're trying to make big business scared of massive liabilities such that they come to the table. And I don't mean come to the table in the one-off sense of resolving the lawsuit with New York, but I mean come to the table and look for political solutions. That's what happened with lawsuits against the cigarette companies. That the threat of continued liability made the cigarette companies more willing to engage with regulators about long-term solutions. But as a lawyer, I think I should say, don't get your hopes up. Don't get your hopes up because first, because of cases like Connecticut versus American Electric Power, there are limits on the available causes of action or claims that can actually work in these cases. And second, and perhaps more importantly, the problems of proof in these cases are really severe. You not only have to show that climate change contributed to Hurricane Sandy, but you have to show that BP or Chevron or other specific actors were responsible. And you have to show that what they did that was wrong contributed directly to what harmed you, and that it wouldn't have happened without their contribution. These are very challenging problems scientifically, and they're challenging problems of proof in a lawsuit as well. These are hard suits to win. So as I said, I'm not going to get my hopes up that these suits alone are going to work. Category 2. These are cases that are seeking indirect, I'm going to call indirect recoveries against private actors. And here the best examples are lawsuits based on fraud or misrepresentation. One of my favorite and also perhaps most disturbing stories in this area relates to the role of Exxon and climate science. So some of you may be familiar with the story of the tobacco scientists who for decades lied or at least obscured the links between smoking and cancer. Well, it seems that the same things have happened in the context of climate change. Decades ago, fossil fuel companies like Exxon learned about the potential effects of their products on the global climate. Protecting their wallets, executives from these companies got together and they tried to think about a strategy. And they settled on a brilliant idea. Follow tobacco's lead, and hire scientists to obscure the links between fossil fuel emissions and climate change. And who did they hire? Literally some of the same scientists who also worked for Big Tobacco. They brought them in and they engaged in a decade-long campaign, again, of obscuring the link between a profit-making business and potential societal harms. Now, in the last few years, some of this information has come to light. And although those revelations have not led to major action against the oil companies by the federal government, they did spur action among the states. And in particular, the attorneys general in Massachusetts, New York, and other states came up with a creative legal response. So many countries, including the United States, have laws that we call securities laws that regulate the way that, for example, publicly traded companies communicate information to shareholders and potential investors. And one thing these laws say is that you can't lie about material facts to potential investors to inflate your stock price. If you could do that, then every company that traded on the New York Stock Exchange would always lie about their potential future profits, about all the great things they were doing. You can't do that. And if you do lie, you can be sued for what we call securities fraud. So New York, Massachusetts, and other states had an idea. They said, don't you think investors in companies like Exxon would want to know if the company was aware that their product was going to cause the long-term devastation of the earth? Isn't that exactly the sort of thing that might affect the stock price? And so the state of Massachusetts issued a series of subpoenas, those are requests for documents, to Exxon and other corporations, asking them what they knew and when they knew it, and why they didn't share that information with the public. This, by the way, is one really important thing that lawsuits can do, even if they don't win in the end. Lawsuits can reveal important information about what's going on. The law has a procedure that we call discovery, and it's exactly what the name suggests. It's a procedure by which you can use the courts to discover relevant information about a potential injury. And courts can order parties like Exxon to turn over smoking gun documents that say that they knew about the effect of climate change on date X and chose to not share it with the public. So in any event, Massachusetts issues its subpoenas to Exxon and others, but in response, Exxon adopted a pretty audacious litigation strategy. One thing they did, purportedly, is they went to a member of Congress named Joe Barton. Joe Barton's nickname is the congressman from Exxon. And they complained about these investigations. Joe Barton ran a subcommittee in the House. And so his committee issued subpoenas to the Massachusetts Attorney General, asking for all of the state's internal law enforcement records related to this investigation. Now, to a lawyer, I wouldn't have to say any more. It is shocking that Congress attempted to intervene in an ongoing law enforcement investigation in a state under state law that Congress had nothing to do with. And indeed, eventually, Massachusetts resisted those subpoenas and didn't turn over that information. At the same time, Exxon filed a lawsuit against Massachusetts. And they claimed that Massachusetts was beyond its authority to issue these subpoenas. And they also said that Massachusetts' investigations interfered with Exxon's First Amendment rights to publish junk science about climate change. Now, of course, Exxon has good lawyers. They didn't call it junk science. But that was essentially their claim, that investigating their lies about climate change would chill their ability to do their own research and publicize it. These lawsuits also were defeated, so Massachusetts continued its investigation. And indeed, just in the last year, the state of New York filed a major securities fraud lawsuit against Exxon, alleging that it lied to investors about the consequences of climate change. So what should we make of these lawsuits? Well, no one thinks that climate change is first and foremost a problem about investor protection. And in a way, you might think that these lawsuits are distracting from the real harm of climate change, which is, of course, harm to the climate, not lying to investors. I should also add that it's not clear how much liability is going to be at stake in these cases. Because, of course, New York is not suing for the harm of climate change. It's suing for the harm of the lies as it relates to investors in Exxon. So that's a much smaller liability than for climate change overall. But still, in my view, these suits are important. For one thing, they can reveal information using that discovery process I mentioned about a potential conspiracy among executives at large corporations to keep the public unaware of the harms of climate change. It's also possible that those revelations might change the national commentary around climate. Again, using the analogy of tobacco regulation, it was only after people became aware of what was going on in big tobacco that we were able to generate the public interest necessary to have regulation of smoking. So it's possible that these lawsuits might make fossil fuel companies softer targets for ultimate regulatory interventions. So far, we've talked about two categories of lawsuits against private actors. But there's another category of defendants, of people who can be sued, that we haven't mentioned yet. And that's the United States government. So after the election of President Trump and his subsequent appointments to the US Supreme Court, every branch of the federal government seemed lined up against climate action. The president withdrew the United States from the Paris Climate Accords. The Supreme Court, which had previously stalled the rollout of the Obama Clean Power Plan, had blessed the rescission of those reforms. And Congress's signature achievement, a tax bill, reduced incentives for clean energy and allowed for drilling in the Arctic National Wildlife Reserve. But federal actors are not the only government actors. The American system divides authority between the center and the states. And we have a long history of conflict between states and the federal government. For example, when the president announced the United States' intention to withdraw from the Paris Agreement on climate, the governor of California said, "I'd like to sign up." One particular version of this conflict that has reached prominence in recent years have been lawsuits by states against the federal government, asking courts to order the federal government to take certain actions in a particular regulatory space. We've seen these lawsuits related to immigration, voting rights, civil rights, reproductive rights, the environment, and more. Before his downfall, here's A.G. Schneiderman of New York, who bragged that his office had sued the Trump administration 100 times in the first year of the administration. Environmental law has been at the center of a number of these lawsuits. A decade ago, a group of states led by Massachusetts sued the Environmental Protection Agency in a case called Massachusetts versus EPA, demanding that the EPA regulate climate change. The case went all the way up to the Supreme Court, and this time the states won. The issue was standing. And the Supreme Court said that yes, states do have standing to sue the EPA to demand regulation. Indeed, the Supreme Court implied that sometimes states are going to have standing, even when private individuals would not. Now, in this particular situation, the states ultimately dropped their lawsuit because the Obama administration's EPA signaled it was going to regulate climate. So there was no need to go forward with the lawsuit. But of course, with the change in administration, there's a new interest in forcing the EPA to act. And so after the 2016 election, states have begun suing in earnest. They've challenged the Trump administration's decision to rescind various Obama-era regulations, and they've challenged new proposals from the Trump EPA. For example, in 2018, the Trump administration announced plans to reduce vehicle fuel efficiency standards, and states sued to challenge their authority to do that. Of particular interest, I think, is an unusual feature of the Clean Air Act. So the Clean Air Act says that the federal government can set vehicle fuel efficiency standards. But it also said that California could set its own higher standards, and any other state that wanted to could follow California's rules rather than the federal ones. So at the time, this was seen as a major innovation, and this kind of federal-state balance seemed to work pretty well until recently when the current administration said it was going to rescind California's ability to do this. So California and other states have sued, demanding the right to continue to be able to regulate on their own. This particular fight, I think, reveals both some of the challenges, but also the opportunities of this type of federal-state litigation. There are all sorts of ways that we could structure federal-state relations. One idea, which seems pretty sensible in areas like air pollution, is to set a federal baseline, but allow states to regulate more rigorously if they choose to. That's what the Clean Air Act did. But the problem with a solution like that is that it's not durable. It's not durable because the US Constitution has in it something called the Supremacy Clause. The Supremacy Clause says that federal law is supreme to state law, meaning that the federal government can preempt, can essentially get rid of state laws that are inconsistent with federal law. So the Supremacy Clause means the federal government has the hammer if they choose to use it. Now that said, the states are not completely powerless, even when the Supremacy Clause kicks in. For one thing, they can file these lawsuits that will at least slow the federal government's ability to trammel state law. But ultimately, as long as the federal government dots its I's and crosses its T's, it will be able to preempt state law. But the other thing these lawsuits can do is they can contribute to a larger political movement about the issue. Because of course, all these choices, both state and federal, are subject to political constraints. And if the states can raise the salience of the issue, if they can make an argument that what the federal government is doing is wrong, and they can persuade enough people, then either the federal government will have to bend, or the people who won't bend will be voted out of office. Or to put it another way, cases like California versus EPA may not be able to stop the federal government from preempting state law, but they can slow it down, and in the process, they can start to build a political consensus that makes it so the politicians in DC elect to pursue another course. Finally, that brings me to the last category of lawsuits, and these are individual citizens suing the federal government. Like suits by the states, sometimes these suits are fairly narrow, asking the court to stop a very particular government regulation on a single pollutant. But sometimes they're much more ambitious. My favorite example here is a case called Juliana versus United States. The Juliana in this case is Kelsey Juliana. She was a then 19-year-old climate activist who at the age of 18 walked 1,600 miles from Nebraska to Washington, D.C. to protest climate action. Juliana and 20 other young people filed a lawsuit in Oregon against the United States government, arguing that the government had known about climate change for half a century and done nothing about it. Indeed, they claimed that the government actually actively encouraged climate change by policies that favored the use of fossil fuels and that discouraged the use of renewable energy. And they asked the court to order the federal government to protect the rights of future generations by acting on climate change. And when this lawsuit was first filed, it seemed off the wall. And indeed, the lawyers for the federal government very quickly came into court and asked the judge to throw the whole thing out. They said, this is just not something a court can do. It's not something that 21 kids from around the country can sue the United States government about. So the first question that these plaintiffs had to face was whether the court would even take jurisdiction over the case. And a lot of people thought the court wouldn't. But these plaintiffs wanted jurisdiction so that they could get discovery, so they could get documents from the government to learn what the government knew, to depose the head of the EPA. And they wanted to get to a trial so that we could have a public hearing about what the government's obligations are to its citizens. And in fact, the court, in hearing the government's motion to throw out the case, said no. The court said, this case has enough merit to go forward. We're going to let this litigation proceed, perhaps all the way to trial. And a trial like this, I think, would be a pretty big deal. A trial of whether the United States government lived up to its obligation to its citizens and to future generations to take care of the climate. Now, historically, as I suggested, courts have been a poor vehicle to sue the government directly. Doctrines like sovereign immunity made those cases hard to win. But over time, those doctrines have loosened such that the court in Oregon, it turns out 2 days after the 2016 election, said this is a case that might work. Now that said, if this case does get to the remedy stage, if these 21 children win in their lawsuit, there's still the question of what the court will actually force the government to do. And my own view is that it's very unlikely that the court is going to issue a broad ruling like the government has to fight climate change now. Courts are still very reluctant to order the government to do something. There's the notion of the separation of powers, and the judiciary is just uncomfortable ordering the executive or the legislature to take major steps like fight climate change. Indeed, between us, my prediction is that ultimately on the merits, these kids will probably lose. But again, as I've already suggested this hour, this case is not only about winning in court, it's also about winning in the court of public opinion. And here, I think the identity of the people who are suing is really important. These 21 kids don't really have a better legal claim than lots of other people who could have brought this lawsuit. But I think they might have a better political claim. I think they tell a compelling story about the harm of climate change and who that harm falls to. And I think much more than a faceless organization, they're a compelling face of climate litigation. Like how advocates of the Endangered Species Act always pick the cutest animal as the marker of the endangered species, I think it is meaningful that the people who are bringing this lawsuit are 21 children who care deeply about the climate. So far, I've told you about 4 classes of lawsuits that I think can help. And I think they can help in large part because they contribute to a political or social movement around climate change. But that claim raises an important critique that's quite common among legal scholars and commentators. There's a common critique in the legal world that it's a bad idea to use the courts to make major social change. The quintessential examples raised by critics are desegregation and abortion. Critics have said that Brown versus Board, the major school desegregation case, and Roe versus Wade, the major abortion case, actually should be thought of as setbacks to the cause of desegregation and abortion rights. And the reason they should be thought of as setbacks, even though they seem like successes at the time, is that they generate backlash. They get people upset. And because these are decisions made by 1 or sometimes 9 judges in black robes, not democratically elected politicians, they don't come with the same democratic and social movements behind them. They seem like solutions imposed from on high. And as a result, they generate backlash. And critics of climate litigation have made the same claim, that suits like Juliana's are going to generate backlash. and that it's a mistake to go through the courts. I think this is an important critique, but I'd like to suggest 3 reasons that I don't think it should apply to these climate lawsuits. The first is, unlike Brown versus Board and Roe versus Wade, the climate cases are not going to result in a single flashpoint decision, like a decision that says integrate the schools, or a decision that says laws restricting abortion are unconstitutional. At best, the climate lawsuits are going to lead to incremental progress, either by deterring private actors or encouraging the government to act. Second, particularly the lawsuits against private actors, like those I mentioned earlier, I think are better analogized to the lawsuits against big tobacco than Brown v. Board and Roe v. Wade. And the suits against big tobacco were important not just because of what they did in court, but because they helped mobilize society and contribute to efforts to increase government attention and action on an important policy topic. And third, litigation about climate is nestled within a social movement. In fact, it's a social movement that I think is underappreciating the role of courts and judges, not the other way around. I spent a lot of time recently thinking about proposals for the Green New Deal, and virtually all of those proposals have nothing to say about the role of courts and judges and lawyers. Now, all of those arguments I just made acknowledge that the point of climate litigation is not to solve climate in court, but instead to contribute to the bigger social and political movement around climate. So where does that leave us? I want to be an optimist, so I want to leave you with the best case, I think, for climate lawsuits. We lawyers get a bad name sometimes, so I'm going to try to give you the best case for climate lawyers. And I told you at the outset that climate lawsuits are not going to solve climate change. So what can they do? First, ambitious and creative lawsuits can contribute to the social movements that represent our best chances at success. Suits like Juliana's can change the narrative around climate change. And suits like the Exxon fraud suit can alter the political environment around climate regulation. For that reason, I think that climate lawyers should be leaning into the political implications of their cases. Lawyers often think that the word political is a pejorative, is a negative thing that they should avoid. But because political change is necessary to roll back climate change, climate lawyers should think politically when they choose which cases to bring, which plaintiffs to rely upon, which arguments to make. I think the elected politicians in those state and local government lawsuits have already realized this, that climate change can be a winning political issue if you structure it right. Meanwhile, I think climate activists who are not lawyers should remember that lawyers and lawsuits can do important work here, and they should be brought into the fold as part of a wider strategy. At the same time, we also shouldn't overlook the important work that smaller, more incremental climate lawsuits can do. A suit to allow California to maintain its special status under the Clean Air Act, or San Mateo's claim related to flooding that's connected to climate change. Those suits matter too. In that light, I wanted to share with you this quotation from a former Obama administration official who spoke at Cornell earlier this year. And here's what she said about climate. She said that we often talk about the kind of expected outcome from climate change, but what is much scarier are the low probability, potentially catastrophic scenarios where we hit different triggers in the climate system and we have nonlinear responses. We don't understand those. We don't know where they are, but every ton you mitigate could potentially help avoid triggering one of those nonlinear thresholds. Incrementalism is actually quite important here, where we don't know where those triggers are. This is the closest to climate optimism that I can find, which is that we don't actually know where things are going to go off the rails. So even a little bit of mitigation actually might help. So climate change litigation is not going to solve climate change. But climate change litigation can be part of an incrementalist strategy that might just avoid one of those triggers that we don't understand. And climate change litigation can be part of the broader political and social movement. That's the only way that we can get global efforts that are going to be the kind of big change that we're going to need to work on climate going forward. Thanks so much for listening. I'm open to taking questions and comments from anyone in the crowd. Thanks. We've got someone back here with a microphone. Go ahead.
Hello?
Yep.
I was just wondering what you thought of this new form of legal action where environments themselves are considered a human person, like making a lake have the same rights as a person or like a forest. Thank you.
Sure. So there have been efforts. There was a recent case where there was a lawsuit brought on behalf of an animal. Here, there's a discussion about efforts where you imbue rights not even into living things, but into parts of the environment. I guess my own view is that I think we're in an all hands on deck moment. And so I strongly encourage creative thinking from lawyers and policymakers. I should also say, though, that I think at least if these are kinds of claims that are going to be brought in American courts, American judges are going to be highly resistant to that type of action. And the reason is the Anglo-American system, for as long as it has existed, has relied on lawsuits brought by people or entities. Now, you might say, well, what about corporations? Those are not people, despite what Mitt Romney and others have told us. But there's a key intermediate step. And perhaps this is the way to think about your suggestion. The intermediate step is that a government actor, for corporations, it's states, imbue them with certain rights. So a corporation doesn't get created out of whole cloth. We need government action to create this category called corporation. So if the United States Congress or the state legislature in New York wanted to imbue the environment with rights, now we're talking. Now the courts might listen, but it's got to go through the political process first.
So we heard about legal resistance within the US, but I understand that there is no global legal framework for other countries like Bangladesh or Vietnam to bring corporations to some international court. But I was wondering if you could kindly comment on that. Like, has there been any attempt similar to the cases that we have heard today, but in an international setting? And if there is something like that of an international framework, I don't know, like that of Geneva Convention.
Fantastic. This is a global problem that demands global solutions. So what's the global legal framework? Well, the global legal order is highly disaggregated. The key actors are primarily states, or by which I mean countries. So the first question might be, well, what about other national systems? Are there ways to bring lawsuits in Germany or India or Bangladesh? And the answer is, yeah, in a lot of these, there are. If you're interested in it, and I think this maybe was sent around to people who are on the list for this seminar, there is the Sabin Center at Columbia has collected a huge amount of information about climate litigation, including international climate litigation. And they've identified cases in something like 70 countries where lawsuits have been brought. So those aren't global solutions in that each one is in one country at a time. But you start adding up dozens and dozens of countries, pretty soon we get to global solutions. What about truly international solutions? The international legal system is set up quite differently than the domestic legal system. And one way that it's different is that we don't have a single international order for all issues. We have one regime of international economic law. Indeed, you might break that down into a regime about international trade law, international investment law, international development law. We have a separate regime about interstate relations. We have a separate regime about international criminal law. And each one of these has more or less teeth. It turns out, for better or worse, that the international economic law entities have the most power, the most authority, the most ability to do stuff. So my 2 cents is that the best efforts on the international stage to fight climate immediately need to be funneled through these economic bodies. The World Trade Organization is one. Because that organization already has a lot of authority, you don't have to build it from the ground up. But again, I'm an all hands on deck kind of person. So I support effort across the international sphere. But I think the economic organizations are perhaps an untapped venue for climate policy.
I was wondering what type of law is it easier to prosecute under, like local versus state versus federal, and I guess versus international as well, like which is more likely to be successful?
So I think the simple answer is always it's going to depend on the particular case, although 99 times out of 100, the answer is not international. International law is not very well developed. It's very hard to enforce. We don't have an international court system that handles civil cases. So the answer is likely not international law. When we talk about local, state, or federal, there are a couple of considerations. So one is this idea of supremacy or preemption that I mentioned before, that if there is a state law that conflicts with a federal law, the federal law essentially stamps it out. Now, sometimes we might think that's a good idea. The federal government can tell the states that they can't allow certain abhorrent practices that we don't like. But sometimes we might be frustrated when the federal government goes the way we don't like, and we prefer our state's decision. So one thing you're going to need to ask is, if you prefer state or local law, has federal law stamped it out, or is it still good law? But then you go into any lawyer's office on any case, and they'll want to think about the specific facts that you have, about whether your argument makes more sense as a matter of New York State environmental law or federal environmental law, and which one of those sets of laws is going to give you the biggest recovery, the best remedy at the end. That's a case-by-case inquiry, which is another way to say it's a full employment opportunity for lawyers. Thanks.
It's okay, I can show.
Okay, and I can repeat it also.
Yeah. So I was wondering more about the Clean Air Act.
Mm-hmm.
You were saying that California originally could set its own standards. So I was wondering, why was it California that was chosen to set its own standards, and why couldn't other states set theirs as well?
Great. So the question is, why was California special? And in one sense, I should say it didn't have to be. All sorts of institutional designs are available and used in different types of regulation. So you could let every state set their own standard. You could let there be a federal baseline and an exception just to go up. You could let every state do their own thing with no federal baseline. All choices are available, and we use them in different places. What happened in the Clean Air Act, to give a kind of short version of the story, is that everybody just understood that Los Angeles was special. And it was special because it was understood to have worse pollution than basically anywhere else in the country. It was a city of cars. And I grew up in Southern California, in San Diego. And when I grew up, there's one thing you knew, which is that you needed to resist LA encroaching south because it was going to bring smog to San Diego. It was going to bring air pollution. So LA just had this special status. I have not looked at the numbers. I don't know if that special status is in fact deserved. I don't know if it was that much worse in LA than in Cleveland or somewhere else. But at least the perception was that LA was in fact worse. So California was given this special dispensation. It didn't hurt that the president at the time, Richard Nixon, had been governor of California. He understood the special status of California. So what the regulators thought was that we want to set a federal standard. There are a lot of reasons it's good to have a single standard for the whole country. It's easier for people who are regulated. You don't have to think, okay, what's the Connecticut rule? What's the Massachusetts rule? What's the Tennessee rule? No, we have a single rule that we all decide is right. But LA is special. So we're going to let California have its own rule. But then some of the other states said, wait a second, we kind of like what California is doing. So they added this provision that said, okay, if California sets a new rule, other states, you can pick the California rule or the federal rule. So we have 2 rules. Still not so complicated, not 50 rules for industry to have to follow, but acknowledging some variation in the states. So that was just the design that happened to be chosen. And as I said, it worked without much objection until just a couple of years ago.
So you mentioned some cases in which like liberal or blue states went against the government I was wondering if there's any cases of like more red states maybe filing lawsuits against the government for more regulation and how successful those have been.
Great. So let's see if this surprises you. From 2000 until 2008, almost all of the lawsuits were filed by blue states against the government. From 2008 to 2016, they were almost all filed by red states against the federal government. And then from 2016 to the present, they were all filed by blue states. Anyone detect the pattern? Absolutely. So during the Obama administration, huge number of lawsuits, Texas being the primary state that led this. In fact, the then Solicitor General of Texas said that his job was wake up in the morning, sue Obama, go to bed. Now, they were suing on different sorts of issues. Immigration was a big area. Attempting to roll back regulation, an area. So this is an equal opportunity business. It just so happens that the political environment today is such that it makes sense that the states that are going to want different policies out of DC are New York and California and Massachusetts, not Texas and Alabama as it was during the Obama administration.
Hi. So my question is for the New York City versus BP case you talked about. You said that they would need to prove that climate change was a direct cause of Hurricane Sandy and that these companies were also the cause of that. Did they ever get anywhere close to finding any kind of linkage between those?
Thank you so much for asking that, because that was part of the pitch that I was hoping to make to this audience. So that case is ongoing, and these cases are going to be ongoing. And here's where lawyers like me try to find people who have actual knowledge about actual things in the world, not just this law stuff that I've been talking to you about. We need scientists at places like Cornell to help us do that. The law over the years has developed a pretty sophisticated way for how to think about scientific evidence, something that I won't bore you with, but I bore my students with. But what we need are actual scientists who've published highly accepted peer-reviewed science to explain to us how this stuff works. Is New York going to be able to make its case? That's a scientific question as much as it's a legal question. But these groups need to work together. Lawyers can explain to scientists exactly what it is we need to show, but we need scientists to do the work. And I think that, and maybe for good reason, scientists are often scared of lawyers. They don't like going into court. They don't like the idea of being a paid expert witness. But New York only wins this case if eminent scientists come into court and explain to a judge why climate change contributed to Hurricane Sandy, why BP is at fault, and why $20 billion is going to make it so New York can survive. That's a task for people like many of you in this room more than it is for me.
Hi. Thinking about overcoming problems with collective action in global climate change negotiations, do you think that that will become possible? And if so, how? And also, how imperative are these global climate change negotiations in ultimately combating climate change?
If I could overcome the collective action problem in global negotiations, I apologize, but I wouldn't be here talking about BP or New York versus BP. I'd be trying to solve global climate change. I hope so. I think that's necessary. I don't have the obvious way that that's going to happen. I think, though, that these are all political decisions. I think these are all driven by public attitudes, by the incentives for politicians. And I think the first step in making this happen is that elected leaders need to understand that action is going to be required or they're going to get voted out of office. Those are the incentives that politicians respond to. And we shouldn't blame them. Everyone responds to the incentives around them, and politicians want to keep their jobs. They want to get elected to higher office. And to do that, they have to provide their citizens with what their citizens want. And so if the citizens demand action on climate change, politicians are going to have to deliver. But until those demands are made, it should not be surprising that politicians are dragging their feet.
Do you think federalism allows climate change activists to better enact measures to combat global warming?
So I don't think there's a right answer to how power should be divided. You have what were called unitary states, where all the power is in the center. You have highly decentralized states, And you have places in the middle, like the United States, where there's somewhat of a balance between federal and state power. I'm much more of a pragmatic sort of person. I don't care what the right design is. This is the one we've got. And what do I do with the one we've got? Well, I'm going to pull all the levers that are available. And so if the EPA would act on climate, that's great. And I'm very happy about that. But if the EPA is not going to act on it, one thing federalism does is it gives us other outlets. Now, in a kind of reversed situation where the EPA is acting and the states are dragging their feet, then I'm going to be up here complaining about state inactivity. But this is the system we have in the United States. This is one other place, by the way, that I think it would help for lawyers and climate activists to communicate. Lawyers think about these federalism problems all the time, and we can help climate activists understand kind of where the veto points are going to be, because we often run into those when we're bringing these lawsuits. But you've got to fight with the government that you've got rather than the one you hope to get.
You mentioned the Green New Deal earlier.
Mm-hmm.
Would you be able to kind of comment on how feasible you think that would be, and also the differences between sweeping policy changes versus sweeping like legal rulings?
Sure. So it's a little hard, I think, to comment on the Green New Deal because that's a label that has been applied to a lot of different ideas. It's a great label. I think it's a really effective slogan. And there are dozens, if not more, proposed Green New Deals. And I can't tell you my rank order preferences among them. My own guess, and this is really just a guess, is that there will be some action that will happen that someone will call a Green New Deal. Whether it's the Green New Deal you like or the Green New Deal I like, that's a different question. But the second half of the question, I guess, was about political versus legal mechanisms. Again, the lawsuits aren't going to do it. The lawsuits aren't going to do it. The lawsuits might lay the groundwork for the policy change. They might lay the groundwork by making people really angry at Exxon. Or they might lay the groundwork by making Exxon realize that it needs to take some action in order to avoid further liability. There was an interesting study recently, I think, or at least I find it interesting, published by a couple of lawyers named Janice Nadler and David Dana. And one thing they wanted to look at is, well, what happens when corporations take voluntary steps to improve their behavior? Does that make it more or less likely that you're going to get government regulation? Because you might think that if corporations are handling a problem on their own, people aren't going to demand government regulation. So they did a bunch of experiments, not with governments, but with regular citizens. And it turns out that when corporations take steps on their own, it actually makes people more interested in government regulation, not less. People don't think, oh, the corporations are handling it, we don't need the government. Instead, what they think is, oh, this is a good idea. Everyone should have to do it. And so if you can threaten Exxon with a lawsuit such that Exxon takes steps towards green energy, that actually makes it more likely that the government will make BP do the same thing than the other way around.
One more question?
Yep.
So other countries in the world seem to have figured this out. Is there something that's sort of fatally wrong with the US? I mean, Europe, Japan, now China, soon India. We seem to be dragging our feet in a way that's just unbelievable.
A couple of thoughts. So first, I'm not so sure that other countries have figured it out. I think that we know more about what's happening in the United States than in a lot of other places. And I've read some things that are discouraging about some of the efforts in places, even like Germany, where I had some hope that there was going to be movement forward, that there's some backsliding. So I'm not convinced that anywhere has it figured out. What explains the particular pathologies of the United States? Part of it is we have a particular government structure that I think makes it hard to have big social policy change. This is a question for political scientists, but you can ask them about veto gates. and institutional design, and they'll tell you why it's hard to make major social change in the way the US system is set up, as opposed to systems that are, say, parliamentary. So there is something about institutional design. I think also the United States has a massive fossil fuel industry, and it should not be surprising that in a country with a massive fossil fuel industry, there's a lot of money that supports political causes that do not call for the regulation of fossil fuels. But again, I think that those forces can be overcome with social action, with 150 people coming to a talk about law and climate change on a cold but pretty sunny day outside when there are many other things you can be doing. So I remain, I would say, cautiously optimistic that at least we're moving in the right direction. We're moving in the right direction in rooms like this with people like Juliana, with proposals like the Green New Deal to be taking this issue seriously. But it's a tough, tough problem. So we have to keep working. With that, thanks so much.
Thank you.
Thank you.